Joining me now, assistant professor at Brooklyn Law School, Alexis Hoag, and CNN columnist and lawyer Jill Filipovich. Alexis, professor, I want to start with you. That distinction seems to be the most important thing this morning, where you have at least three justices who want to just throw out Roe altogether. And then you have maybe two who want to say Mississippi law can stand beginning at 15 weeks. What's the distinction? Why is this important?
I think it's important to identify which justices are which. So on the far right, we have Alito, Gorsuch, and Thomas. And then those two sort of in play, perhaps Kavanaugh and Barrett. And so what could happen is Chief Justice Roberts does want to maintain the legitimacy of the court. So he may try to thread the needle so that we retain somehow Roe, but yet uphold this Mississippi ban. And to me, that is the best case scenario. Jill and I are actually classmates from law school. That is terrifying. And I assume you're on the same page with me there.
Definitely. Getting rid of the viability standard, which is currently what's in place. So essentially the law right now says that states cannot completely ban abortion after the point of fetal viability. So after the point that the fetus can survive outside of the woman's body. That happens well after 15 weeks of pregnancy. So even if the Mississippi law gets upheld at the 15-week standard, as Alexis says, the best case scenario, we're doing away with now decades of established Supreme Court precedent and throwing this huge wild card out to the states. If no longer viability, well, why 15 weeks? Why not 6 weeks? Why not 4 weeks? It creates total legal chaos and functionally guts Roe without actually doing it outright. And that's the best case at this point.
That's what you consider to be the best case. The alternative is the Gorsuch, Thomas, Alito way, which is just do away with it completely, overturn it completely, which means each state gets to decide, which means as many as 20 states, maybe more, just outlaw each and every abortion.
Exactly. And that's what is so terrifying, is leaving this decision up to the individual states. And if we can return back to our period of Reconstruction following the Civil War, the whole point of the 14th Amendment was to protect the rights of people that were marginalized. And I'm speaking about enslaved Black people. And so the fact that the 14th Amendment protects individuals' rights to bodily dignity, to liberty, and then to leave that up to the states, the whim of a majority vote of state legislatures, cuts directly against what we have with the 14th Amendment and the Due Process Clause.
Let's talk about Brett Kavanaugh. You identified Brett Kavanaugh as one of the big unknowns here, along with Amy Coney Barrett. Look, maybe John Roberts, too. John Roberts seemed to indicate 15 weeks might be okay with him, but we'll leave that aside. Let's talk about Brett Kavanaugh, because during his confirmation hearing, Brett Kavanaugh talked about the importance of precedent and really seemed to indicate that he believed in relying on precedent here. He talked about Roe and he talked about Casey. Listen to this.
What would you say your position today is on a woman's right to choose?
Well, as a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor.
Precedent on precedent. It was enough to convince Susan Collins, who is pro-choice, to vote to confirm Brett Kavanaugh. This is what she said at the time.
We talked about whether he considered Roe to be settled law. He said that he agreed with what Justice Roberts said at his nomination hearing, in which he said that it was settled law.
But yesterday, Jill, Brett Kavanaugh could not have been more different. He put together a laundry list of cases that the Supreme Court had overturned to suggest precedent didn't matter as much to him, or these are the places where precedent didn't matter. And then he also said this.
The reason this issue's hard is that you can't accommodate both interests. You have to pick. That's the fundamental problem.
And he went on to say if you have to pick, it should be the states, more or less, who have to pick, or indicated that's what he might think. That's a big change. What he said yesterday, really, it's an important thematic difference from what he was saying out loud in 2018.
Well, women's health groups, feminist groups knew that in 2018, when Kavanaugh was being confirmed, that he didn't support Roe v. Wade, that he would be a conservative vote, likely against abortion. Of course, none of us are fortune tellers. None of us can tell exactly how a justice is going to vote in the future. But feminist groups were screaming about the Kavanaugh nomination because we knew that he would be a vote against Roe. Susan Collins knew he would be a vote against Roe. Any sentient person paying attention to Brett Kavanaugh's history and his views knew that what he was saying about precedent was a bit of a weasel dodge. You know, he was saying, all right, well, I care about precedent, and that's fine. He can say that, and that can be true, and then he can also, as a judge, decide that in this particular circumstance, he doesn't think that the arguments for precedent are as strong as other arguments, which is exactly what he indicated in the arguments yesterday. None of this is a surprise. It was entirely predictable. Susan Collins should have predicted it.
She was asked about this last night by CNN, and at the time, her response was she hadn't seen it yet. She needed to go look at the video to find out how she felt about what Brett Kavanaugh was now saying. Jill, Alexis, classmates, I'm glad for the reunion here. Thanks so much for being with us.
Thank you.